people, State of Michigan versus Norman James Bowman, case number 12-20901FY. Mr. Bowman, please state your full name for the record.
Norman James Bowman.
Mr. Bowman, as I indicated, I have a felony complaint. It's alleged on or about February 19th, 2012 in the village of Marion of Osceola County. It's alleged you did, in the course of committing a larceny of U.S. currency, use force or violence against a person present, Andrew Reed, and in the course of that conduct possessed a knife, a dangerous weapon, contrary to state law. This is titled armed robbery, and it's a felony charge that's punishable by up to life or any term of years, unless aggravated assault or serious injury involved, then not less than 2 years, and DNA to be taken upon arrest. You understand the charge and the maximum consequence you're facing?
Yes, sir.
And also indicates habitual offender fourth offense notice. It says take notice the defendant was previously convicted of three or more felonies or attempts to commit felonies, and that on or about June 16, 2006, he or she was convicted of the offense of felony police officer assaulting, resisting, obstructing in the 38th Circuit Court for Monroe County, State of Michigan. And on or about January 26, 2007, he or she was convicted of the offense of felony larceny in a building in the 38th Circuit Court for Monroe County, State of Michigan. And on or about August 3rd, 2007, he or she was convicted of the offense of felony police officer fleeing in the third degree in the 3rd Circuit Court for Wayne County, State of Michigan. Therefore, you could be subject to an enhanced sentence under that enhancement. Do you understand that?
Yes, sir.
All right. Because you're charged with a felony offense, I must advise you, you have certain rights. You have the right to remain silent. Anything you say orally or in writing can be used against you in court. You have a right to have an attorney present during any questioning. If you can't afford an attorney, one will be appointed for you, a public expense. And you have a right to have an attorney at all other court proceedings. Do you wish to have the court appoint an attorney to represent you in this case?
Yes, sir.
I'll note for the record you have completed a request for court-appointed attorney. It indicates your legal address anyway as Catherine and Taylor, Michigan. Is that correct?
Yes, sir.
And at that location, did you live with family members or pay rent or room or board, or what did you do at that location?
I live with a family member.
Okay. Your marital status is what right now?
Single.
Single? Do you have any dependents or children?
No, sir.
Do you have any source of income?
No, sir.
Do you receive any government assistance?
No, sir.
Do you own any real property? Do you own a car, a boat, a motorcycle, four-wheeler, snowmobile, or have money in the bank?
No, sir.
Any obligations you have to pay on a regular basis?
No, sir.
You don't have court fines or anything else from any other place that you're supposed to be paying on or anything? I'm thinking any debts, not just court fines, but any debts at all, medical bills or credit cards or...
No, sir.
None. Okay. Well, considering the defendant has no viable means of income, I'm going to grant his request for a court-appointed attorney. I'm going to indicate that I'm going to appoint Dennis Duvall to represent you. Mr. Duvall has a contract with the 49th Circuit Court as a public defender involving felony cases. Do you understand this?
Yes, sir.
All right. Let me make the notations here. Sir, you have a right to have a preliminary exam within 14 days of today's date. At a preliminary exam, the prosecutor must do two things. One, establish that a crime was committed, and two, establish probable cause to believe you were involved in that crime. Do you understand that?
Yes, sir.
To protect your rights, I'm putting two dates on the court calendar. One is what we call a pre-prelim that's scheduled for next Thursday, April the 5th, 2012 at 9:15 a.m. That's a time of day when your attorney can meet with the prosecutor and discuss the nature of your case. I suspect he'll come and talk to you before or after that meeting, all right? And your actual preliminary exam at this point in time, if you and your attorney choose to have it, is set for Thursday, April the 12th, 2012 at 1:30 in the afternoon. Do you understand that?
Yes, sir.
Finally, because you are facing a charge that's punishable by up to life in prison, and to note that you are on or were on felony probation and had absconded from that probation or had a warrant or a parole detainer of some nature, I'm going to, at this point, order no bond in your case. So you'll be held without bond. You understand that?
Yes, sir.
Any questions of me?
No, sir.
This concludes your arraignment then. Thank you.